Hello everyone, welcome to the next hearing. Today we discuss hate speech and selective law enforcement in India. I am Amod Vidhuri and today we are going to dive deep into one of the most critical issues facing our democracy. Our constitution guarantees equality under Article 14, free speech under Article 19 with reasonable restrictions, and the right to life and dignity under Article 21. Yet in practice, we see a troubling double standard. Powerful leaders can engage in hate speech without consequence, while activists, journalists, and dissenters are met with severe legal actions. Today we will explore what hate speech really means and how it's defined in India. Case studies from events like Delhi Riots of 2020 and other recent incidents, and how law enforcement and the judiciary are selectively applying these laws, the political tactics and loopholes that protect the powerful while targeting the vulnerable, and most importantly, what you as the citizens of this country can do to uphold the rule of law and fight for true equality before the law. Let's begin our journey into understanding this critical issue. To understand the controversy, we must start with definitions. Hate speech is generally defined as any speech, action, or expression that incites violence or hatred against a particular group based on attributes like religion, caste, gender, ethnicity, or nationality. In India, several legal provisions came into play. Article 19 guarantees freedom of speech and expression, yet this right is subject to reasonable restrictions. Under Article 19, in the interest of public order, security and morality, the Indian Penal Code through Section 153A criminalizes speech that promotes enmity between different groups, and Section 295A penalizes acts intended to outrage religious feelings. Additionally, laws such as UAPA have been used to arrest individuals for expressions labeled as anti-nationals. In theory, these laws should protect our constitutional rights equally. However, what happens when the same provisions are applied unevenly? That's the issue we are tackling today. Let's now explore how these laws are being applied in practice and how that application often depends on who is speaking. One of the most alarming trends we see today is selective law enforcement. Let's examine a few real-world examples that illustrate this double standard. During the Delhi riots of 2020, several ruling party leaders delivered inflammatory speeches that clearly incited violence and hatred. Despite the clear evidence in video footage and widespread media coverage, no significant legal action was taken against these leaders. In contrast, numerous activists and student leaders were arrested under the UAPA and charged with sedition for their involvement in protests. Their arrest was swift and severe, leading to long periods in jail, even when their action did not directly incite violence. They have been trying to get bail, but few of them have not got bail even today. This discrepancy directly contradicts the constitutional guarantees of equality under Article 14 and the right to dignity under Article 921. It sends a clear message: the law is not being applied equally. Now let's examine the reasons behind this selective enforcement. Is it simply a failure of the legal system, or is there a deliberate political strategy at play? Investigations reveal that when leaders from the ruling party are involved, investigations are often delayed, minimized, or quietly dropped. Conversely, opposition figures and activists find themselves in the crosshairs of aggressive law enforcement. This results in a chilling effect on dissent and undermines the very principles of a free and fair society. In addition to selective enforcement, we must also consider how the government uses legal loopholes to shield itself and its allies from accountability while targeting critics. Strategic delays in investigation. One tactic is the deliberate delay in launching investigations into hate speeches made by ruling party leaders. For instance, during incidents like Haridwar Dharma Sansad in 2021, hate-filled speeches were recorded and reported, but the subsequent investigation was either stalled or only addressed after international pressure, with no real punitive action taken. There is a highly misuse of anti-terror laws. On the flip side, when activists and dissenters speak out of protest, they are quickly slapped with charges under UAPA or sedition laws. This misapplication of laws not only punishes dissent but also acts as a warning to others who might challenge the status quo. Pressure on corporate donors. Another disturbing mechanism is the coercion of businesses. Reports indicate that after high-profile investigation by agencies like the ED, IT, or CBI, companies that once donated to opposition parties are pressured into making voluntary contributions to the ruling party. This ensures that political funding remains skewed in favor of the incumbent. These strategies reveal a sophisticated system where the tools of law enforcement are used not for justice but as instruments of political control. When the government is able to manipulate these systems, it not only undermines public trust but also erodes the democratic fabric of the nation. In a true equal society, law enforcement would be blind to political affiliation. But the reality is starkly different. While much of the blame is often directed at the executive and law enforcement, the judiciary also plays a critical role in ensuring that the law is applied equally. Yet, even the judiciary has faced criticism for its consistent handling of hate speech cases. Number 1 was landmark judgment on hate speech. Consider the Tehseen Poonawalla versus Union of India case in 2018, where the Supreme Court directed stricter action against hate crimes and mob lynching. Despite this strong stance, we have witnessed numerous instances where similar hate speech incidents involving powerful figures have not been acted upon. Second case is the Shreya Shingal versus Union of India 2015 case. In this case, the court struck down Section 66A of the IT Act, ruling that it infringed on free speech. This was a landmark victory for online freedom. However, in practice, similar charges continue to be used selectively against activists and dissenters. The third reason is judicial delays and selectivity. Many petitions from victims of hate speech or their advocates have languished in court for months, if not years, while cases involving ruling party members seem to be fast-tracked or quietly dropped. The judiciary is often seen as the last bastion of justice. But when its decisions are influenced by political context or when there is a visible disparity in how cases are handled, public trust in the judicial system erodes. While landmark judgments are applauded in theory, the practical enforcement or lack thereof reveals that even our highest courts are not immune to the pressures of political convenience. In today's digital era, hate speech has taken on new dimensions. With the advent of social media, hate speech can spread like wildfire. This not only polarizes communities but also becomes a potent tool for political manipulation. The role of IT and misinformation campaigns. Political parties have now established dedicated IT cells and troll armies that push hate narratives online. These groups can manipulate public opinion by flooding social media with inflammatory content, while simultaneously discrediting opposition voices through coordinated defamation campaigns. Second is election time polarization. During election cycles, hate speech often reaches a fever pitch. Studies have shown that spike in hate speech on platforms like Twitter and Facebook correlate strongly with political sensitive periods. This not only undermines constructive debate, but also creates a hostile environment for dissent. Number 3 is the economic angle. One must also consider the economic impact. When businesses and corporate donors are coerced into supporting a particular party due to targeted investigations and raids, it creates an environment where political power is bought rather than earned. This in turn reinforces the cycle of selective enforcement and biased funding. The digital landscape has amplified the already skewed nature of selective law enforcement. When hate speech becomes a tool for political gain and when digital platforms are manipulated to serve political interests, the very foundation of democracy is at risk. The challenge lies not just in regulating hate speech, but in ensuring that such regulation is applied impartially, regardless of political affiliation. As future professionals, activists, and engaged citizens, you have a critical role to play in challenging these double standards. Here are some actionable steps you can take. 1. Educate yourself on the constitutional rights. Deeply study Articles 14, 19, and 21 to understand your rights and the intended limits of these protections. Analyze landmark cases that have shaped the interpretation of these rights. Number 2 is use legal tools for accountability. File public interest litigations where selective enforcement is evident. Leverage the Right to Information Act to expose discrepancies in how laws are enforced. Engage with legal aid organizations to support cases that defend free speech and equality. 3 is engage in digital activism. Share verified information, counter misinformation, and create digital campaigns to expose selective law enforcement. Work with independent media to highlight cases where the law is applied unfairly. Number 4 is form advocacy groups. Join or establish groups dedicated to judicial accountability and reform. Participate in public forums, webinars, and panel discussions that push for equal enforcement of law. By challenging selective law enforcement, you not only protect your constitutional rights but also help to build a more equitable society. Remember, the law is a tool for justice, not a weapon for political suppression. Your activism, legal expertise, and commitment to transparency are vital in ensuring that justice is truly blind. In conclusion, the selective enforcement of hate speech laws in India reveals a deep-rooted challenge to our democratic ideals. When the law is applied differently based on political affiliation, we not only undermine the principles of equality, but dignity but also threaten the very fabric of our democracy. As students, legal professionals, and responsible citizens, we must continue to question, challenge, and hold our institutions accountable. Only by doing so can we ensure that the rule of law applies equally to all, regardless of power or influence. Thank you for joining me in this detailed explanation. If you found this insightful, please like, share, and subscribe. I invite you to share your thoughts in the comments. What step do you think we must take to guarantee equal enforcement of the law? Let's continue this important conversation. Stay informed, stay engaged, and together we can work towards a more just and equitable society. Until next hearing.